was asked to come and speak specifically about coming soon signs, which is what we are going to talk about this morning. First off, it is a very hot topic, I know, in your area. There's a lot of questions about coming soon, whether they're legal, whether they're illegal, whether they're a violation of the MLS rules, the license law, the code of ethics. Could your board do something to prohibit them? All these kinds of questions. If it's any consolation, you're really not alone, because coming soon signs are not unique to Dayton. They're not unique to Columbus or Cincinnati. They're across the state. And frankly, they've been around now for a few years. One of the handouts that you have out in the lobby to pick up besides the PowerPoint is an article that I wrote over 2 years ago about coming soon signs. And nothing really has changed since I wrote that article. But we still have a lot of questions about it, and in some areas they didn't catch on as quickly as they have in other areas, and so perhaps they're just becoming a little bit more popular in your area, and so that's probably why you have more questions about them and about, you know, how the law and ethics and the MLS rules apply to coming soon signs. So we're for sure going to talk about that. We're here for an hour today. Hopefully we'll have time to get to also the other topics. Well, I guess I should have mentioned, when you talk about coming soon signs, it usually involves also the topic of pocket listings. So we'll talk about pocket listings as well. If we have time, if we don't spend the whole hour on those two topics, then we're going to talk about working with minimum service listings, whether you have a minimum service listing, you want to get into perhaps offering less than full services on your listings, allow the sellers to do some of the work themselves. Even if you're not interested in a minimum service brokerage model for your company or on a case-by-case basis, you may be having buyers who want to see those types of listings. And so we're going to talk a little bit about, you know, how you work with sellers who are subject to a minimum service. Are there any risks for you as a buyer's agent so that you don't somehow cross the sign and begin to do things that interfere with that other realtor's relationship, and that you don't somehow imply a relationship with that seller that you don't represent when you're working directly with a seller who's listed with a minimum service broker. So we'll talk about those issues. We're also going to talk about working with for sale by owners. Kind of a similar situation. You know, what are your parameters when you are showing a property to a buyer you represent and that seller is unrepresented? How does that work, and what are the things you need to be mindful of? And then finally, and I'm not sure we're going to have time to get to it, but Nick asked if we do have time, if we could just kind of go over some of the do's and don'ts with respect to multiple offers. We know it's a hot market. We know we're getting a lot of offers on the same properties. And I think sometimes it's always good to kind of review some of the provisions regarding that and talk about some of the counseling you might want to do with your clients up front to avoid the disappointment that's always going to occur when you have multiple offers. Because when you have more than one buyer that wants a property, somebody's not going to be happy at the end of the day, right? So try to reduce that likelihood. But let's get started with our big topic, and that is coming soon signs. As I mentioned, they've been around for a while now. I would say probably for about 4 years at least in Ohio. I'm not really sure what prompted the use of coming soon signs. I mean, I could speculate. I think perhaps when we were in a market that had a lot of properties that were foreclosure properties, we had properties that were sitting for quite a while. And in some instances, there was a lot of work that was necessary to be done even after you got through the whole legal process for these REO properties to be in the shape to show. And perhaps maybe those lenders were telling their realtors, listen, we're going to list it with you. It's not ready to show. Get in there, get it cleaned up, help us facilitate that. But in the meantime, we want the neighborhood, we want the market to know that this property is going to be coming on the market and to generate some buzz about this property. And so I think perhaps maybe that was when coming soon signs started. I don't know. I can't state that as a fact, but that's one speculation that I guess I have. It certainly has caught on. And I think there are a lot of good reasons why people might want to use a coming soon sign. The one I just gave was an REO property, but it could also be an investor-owned property where they buy a property, they're going to fix it up, and they're going to put it on the market. Again, they want to let the public know that this property is going to be available soon for purchase. It may be other situations where you have a seller who is selling the property. Maybe it's in an estate, maybe it's their own property, and they've lived in it for 45 years, raised all their children. It's going to take them quite a while to clean out that basement and that attic and get it painted and get it all ready to be shown. And again, sometimes they want to let people know that this listing is going to be coming on the market. You know, the bottom line is, usually with the coming soon sign, what they're trying to accomplish is to create some buzz about the listing, right? They're trying to let the public know that this is a property that's going to be available. It's not available right now, but it's going to be available to be shown and for purchase. Just from a pure standpoint, there's nothing wrong with that. If you were putting up a sign saying this property is going to be coming on the market soon, and that's a true statement, there's nothing illegal about that. Where the problem lies, and what people get upset about, is that they are being led to believe that the property is not available to be shown. They therefore are not able to show it to their clients, or a buyer calls the listing agent directly and is told it's not available to be shown. They're given a date when it will be available to be shown, and before that date, a sale pending sign or an in contract sign, whatever the sign is that you use in your marketplace, goes on the property, or it goes in the MLS as pending before you believed it was even supposed to be shown. And that's where everybody gets upset, right? That's where everybody gets upset. Because the belief is that the property really was available to be shown, but the listing agent was shooing away cooperating realtors because they were trying to do what? They were trying to sell it to their own buyer or buyers that they would capture. So that's the big issue that everyone is concerned about. So let's look at a few things. Let's talk about some of the license law provisions that already exist, what the Division of Real Estate's position is on coming soon signs, what the MLS rules say, what the code of ethics that apply to you as realtors provide, and how it would apply to a situation such as that. Okay, first, let's clarify about whether or not these properties are listed or not listed. Because when coming soon signs first came about, there was a lot of confusion. People believed, well, they're not really listed. How can they put a sign in the yard if the property's not listed? Well, first of all, under Ohio license law, you do not have to have a listing in order to put a sign in a yard or to otherwise market a property. You don't have to have a listing. What you do need is the consent of the owner. So if the owner says to you, Peg, I want you to put a coming soon sign in the property. I'm not going to list it right now. I'm probably going to list it with you down the road, but I want you to go ahead and put a coming soon sign in the yard. And the seller has consented to you doing that. They've asked you to do that. You can do that without violating the license law. Now, what could be a problem under the license law is that if somebody calls you and says to you, hey Peg, I see you have this coming soon sign in the yard, so you have this property listed, and if I say yes I do, and I don't, that's a knowing misrepresentation. I know I don't have it listed, I'm saying I do, so that's a knowing misrepresentation, and that could be grounds for that licensee to be disciplined under the license law, okay? It's a violation to make a knowing misrepresentation, could also be considered to be misconduct. So if somebody's telling you it's listed and they're not, that's a problem, okay? How do you know if it's listed? You have the ability under the Realtor Code of Ethics to pick up the phone, call that agent whose sign is in the yard, and ask if it's listed. If they refuse to answer your question, they tell you to pound salt, then under the Realtor Code of Ethics, that gives you the green light to contact that seller directly and ask them, is the property listed? What's the nature of the listing? And when does the listing expire? If the answer is it's not listed, either the realtor tells you, no, I don't have it listed, I just have authority to put a coming soon sign in the yard, but they're going to list it with me once the renovations are done, but I don't have it listed right now, or the seller says, no, it's not listed, then what can you do? Make a pitch to get the listing, right? Because if it's not listed with another broker, you're free to make your presentation and to try to acquire that listing because it's not subject to an exclusive right to sell agreement at that time. So you're not interfering with anybody's agency relationship, because if all they have is authority to put a sign in the yard, you are free to try to take that listing yourself. But you do want to make sure that you're exercising due diligence to determine whether in fact it is listed by first talking to the listing agent. And if the listing agent won't answer your questions, then you have the right under the Code of Ethics to contact the seller to determine if it is listed, the nature of the listing, and the expiration date. If the seller says, yes, it is listed, then you have to say, well, thank you very much, good luck, and hopefully when it's available to be shown, we'll show your property. End of discussion, and be professional and walk away from that conversation with that seller because they are subject to an exclusive right to sell. Most of the time when you see a coming soon sign, the property is probably listed, right? And for the reason I just described. If it's not listed, right, anybody can come in and swoop in and take that listing. So most of the time it is listed. So we're going to go with the presumption that the property is subject to an exclusive right to sell agreement. However, the seller has authorized a coming soon sign to go up, and the property is not available to be shown yet. So is that a problem under the license law? The Division of Real Estate takes a position that the seller has the right to determine the marketing strategy for their property and to determine what signage goes on their property. So if a seller wants a coming soon sign to be placed in their yard or to be otherwise marketed as coming soon, that is the seller's right to do that, and the listing agent can legally follow that directive. What the division is concerned about is making sure that the seller is making an informed choice about using coming soon as a strategy, and making sure that the seller understands that, if we list it now, but we don't let people see it for a couple weeks, we may be losing out on some buyers who are trying to buy property during that 2-week time period because we're not letting them have access to the property. But as long as you discuss that situation with your seller, you discuss the benefits of putting the property in the MLS, making it available to be shown, that you're going to get the wide exposure that's provided by the MLS, the Division of Real Estate takes the position that the seller is then able to make an informed choice, and that is the seller's right to make that informed choice as to whether or not they want to use coming soon as a strategy. The other concern that the division could have would be the scenario we talked about in the beginning, which is what everybody's gets upset about, which is they're told it's not available to be shown, you tell your buyer it's not available to be shown, and then it goes sale pending. The division, I think, also has a concern about that, and the concern could be the knowing misrepresentation. Did you knowingly tell another realtor or another buyer that the property was not available to be shown when in fact it was available to be shown? And if that can be proven after an investigation by the division, that could be a possible license law violation that they could pursue against that licensee. All right, we've mentioned the Code of Ethics a little bit, but let's move on and talk about the MLS and talk about the, whoa, what did I do? What Nick said I would do. I would push that wrong button. Oh, he knows me so well. Okay, so let's talk about the MLS and the NAR Realtor Code of Ethics, which you all agreed to abide by when you joined the Dayton Area Board of Realtors. First of all, your MLS, as you know, has rules that require that if you have a listing contract, you have a certain time period in which you must submit that listing to the MLS, right? So I believe here it's 72 hours, excluding weekends and holidays. So as long as you submit the listing within that time period, you have complied with your obligations under the MLS. The way I understand how your MLS handles coming soon signs is that if you have a listing, it's signed, but the seller does not want the property shown for a period of time, whether it's a week, 2 weeks, a month, that the listing must be submitted to the MLS. It is then withdrawn, and you as the listing agent must have some documentation of the seller's instructions that the property not be shown for that period of time to demonstrate that that is why it is being withdrawn, is per the seller's instructions. So that's the process that is to be followed under your MLS rules. And again, the seller has the right under the MLS rules to determine that they want their property not to be exposed through the MLS. They don't want it listed at this point, don't want showings at this point. So that's the seller's right, because again, it's the seller's property. They should have the right to control their property and when it's shown, when it's available for showings. Now what about the Realtor Code of Ethics? What does it provide? Well, the Realtor Code of Ethics has 16 different articles. Article 3 is the one you focus on with respect to this issue. And basically what Article 3 provides is that all realtors have a duty to cooperate with other realtors unless it is not in the seller's best interest. It's generally presumed that cooperating with one another is in the seller's best interest. That is kind of the whole foundation for the MLS system, right? Is that it's not just you by yourself putting a sign in a yard and trying to sell the property. You're making that property known to all the other participants of the MLS. You're offering them cooperation when you put it in the MLS, and you're asking them to make this property known and making it available to their clients, buyers, so that they can see the property and hopefully purchase it. And by doing that through the MLS, you're getting the widest exposure in the marketplace, right? That's why the MLS was created. So there's really kind of a presumption that the broadest market exposure is in the seller's best interest. Would everybody agree with that? Yes. I think we'd all agree with that. But there has to be this caveat that allows the seller to determine what they believe is in their best interest. And that's why you have this exception under Article 3, is that it gives the seller the right to determine what is in their best interest and whether or not offering cooperation is in their best interest. Now, a lot of times when we hear the word cooperation, we think of co-op, we think of fees, and that's not really what cooperation means. Under the Realtor Code of Ethics, what cooperation means is that you're making the property available to be shown, you're sharing information on the property, you're doing everything you can so that this other realtor can provide the necessary information to their buyers and hopefully show the property and get the property sold. So that's really what cooperation means. And so under Article 3 we have some standards of practice, and Standard of Practice 3-10 is the one that requires that in this concept of cooperation that you do have a duty to share information about the property and make the property available for showing. Again, we've got that exception, which is going to be unless the seller has determined that that's not in his best interest. And every once in a while we'll have a seller who doesn't want a certain brokerage to show their property. Maybe they're in a lawsuit with that brokerage, and so they may list the property, but they'll say to the listing agent, I don't want anybody from the Ritenour Realty Company to show my property because that is just a rotten, terrible company and I don't want them in my property and I don't want them to show it. And that's the seller's prerogative. So the seller has decided what's in their own best interests. The same thing could again be true that they decide that for maybe a week-long period or 2 weeks or a month that it's in their best interest not to have the property shown. Maybe it's being rehabbed. Maybe they don't feel it's safe for people to be in there because there's still work going on. There's still paint drying. There's things going on in the property. Maybe they're going to be out of town. They're listing the property, but they're going, on their 2-week cruise with their family reunion, and they don't want the property shown when they're not in town. So there could be all kinds of reasons why a seller determines that they don't want the property shown for some period of time. And again, the Code of Ethics acknowledges that the seller should have the right to make that decision as far as availability of the property for showing. But if you, again, have a realtor who tells you it's not available to be shown for 2 weeks, and that's what you're told, but yet they are showing it to their own buyer clients, now we've got a problem, right? We had a problem under the license law because that could be a knowing misrepresentation. I think you're going to have a proper problem under the Realtor Code of Ethics as well, under Standard of Practice 3-10, because the property is actually available to be shown and you're not offering that cooperation to other realtors. You're only allowing your own buyer clients to see the property. The final standard of practice that I want to mention is Standard of Practice 3-8, and that is the one that says, again, you shall not misrepresent the availability or access to show listed property. So if you, again, are making a statement to other realtors that it's not available to be shown, and in fact it is available to be shown, you're going to have a problem under Standard of Practice 3-8. So when people get upset about these situations, I'll say to them, file a complaint with your local board through professional standards. If in fact you were told the property was not available to be shown and it went in pending, I would call the other agent, find out what happened, talk to their broker or manager, have your broker or manager talk to their broker or manager, and in fact if it was being shown when you were told it was not, you can file a complaint here at the Dayton board through the professional standards process, and that's what that process is for. There are provisions in place that address a lot of the concerns that you have, but they're not going to mean anything unless somebody actually enforces them, right? So if you have that situation, I think if you are an agent in the room, I think you probably want to talk to your broker and manager, let them know what happened, have them call the other company to find out what happened, and avail yourself of the professional standards process. It's not just punitive, the process is also educational, and to make sure that everybody is kind of following the same rules. That's what those provisions are for. But they're only as good as they can be enforced. So don't hesitate to file a complaint, I guess, if you really believe that somebody has misrepresented to you the availability of property to be shown and is not offering you cooperation. Okay, fair housing concerns. This is something that we have heard since coming soon signs became popular. That isn't there the possibility that there could be a fair housing violation as a result of a coming soon sign being used improperly? And by improperly, I mean people are being told it's not available to be shown when in fact it is being shown. So usually the theoretical violation goes like this. A buyer calls the listing agent, sees the coming soon sign, wants to get in the property. They are told the property is not available to be shown. That person is in a protected class. So they say, okay, we'll wait. I'm going to call you back and schedule an appointment the day it goes on the market. And that's in a week. And lo and behold, 3 days later, the property goes up sale pending. And the person that bought that property was not in a protected class. So let's say we have somebody who's Hispanic that wanted to see the property, was denied access to the property, and the property is sold to someone who is Caucasian. Could that be a fair housing violation? Sure, absolutely that could be. Have I heard of any cases being filed in Ohio? No. Have I heard of any cases being filed across the country? No. There was a rumor that there was a case filed in California a couple years ago. We checked with the National Association of Realtors and they say no, that was kind of an urban legend. They had not heard of that case. The California Association had not really heard of that case being filed, and I think they would have known if in fact that type of a fair housing claim had been filed against a realtor who was using a coming soon sign and had denied someone in a protected class access to the property. So across the board, do coming soon signs violate the fair housing laws? I don't think so. Could they in a particular situation? Absolutely. In the situation I described, if somebody truly is denying access to someone based upon their membership in a protected class, that is going to be a problem. As I understand, the Miami Valley Fair Housing Group is aware of the coming soon sign issue. I've heard that they are doing perhaps some testing. They have some concerns that perhaps coming soon signs are only being used in certain price points in the market and not in other price points. So for example, maybe it's only on higher end properties. The coming soon signs are being used as a marketing tool, but perhaps in properties that are more in the $50,000 to $80,000 range, they're not being utilized. Whether or not they can make a connection that there's a fair housing issue there or not, I don't know. I think there would be a lot of dots that would have to be connected. They would have to probably show that in fact that was a policy of the company to not offer coming soon signs in certain markets. I think they would have to show that in fact in those markets there was predominantly a higher percentage of the population that was in a protected class. I think they'd have to show that somehow by not allowing them to have coming soon as a marketing tool that they were in fact being denied a service that would have benefited them. So I think there are a lot of dots that would have to be connected. I don't think you could make a blanket statement that, again, as a concept, that it would violate the fair housing laws, but certainly based upon some type of a policy an individual brokerage may have or a practice that a certain agent follows, there could be some fair housing implications. So I think it's always something that you want to be mindful of, to make sure that you're always making property available to all interested buyers, regardless of race, national origin, color, disability, families with children, all of the protected classes. Okay. Yes?
One of the other issues that came up at the meeting at the Fair Housing Center is limiting access to housing. If you have something in Springboro, for example, and you put a coming soon on it, you have folks from protected classes that are looking for houses. They would literally have to drive through those neighborhoods all the time to find those houses. And their concern was there could be limitations to access to housing.
Yeah, Michael's point that he made was from meeting with the Fair Housing Group here in Miami Valley, that one of their concerns is that when you're using a coming soon sign, people really have to rely on seeing the sign in order to know that that property's on the market. Now, I'm not sure how much the realtors can see the withdrawn listings in your MLS. So if I put a property in the MLS, because I have to comply with my MLS rules, and then I withdraw it per the seller's instructions for 2 weeks, will the other participants of the MLS be able to see that withdrawn listing, or will it not show up? If they search withdrawns, okay, but probably people don't do that. And it would not show up in Realtor.com, correct?
That is correct.
Okay. So Michael's point is, I guess the point the Fair Housing Group made would be that you would have to go to, let's say Centerville or Piqua, and kind of drive around to see that that property is on the market. And perhaps if that's not a neighborhood you live in, you're maybe not going to see that because you don't have maybe any reason to go there, but yet that might be a property that you might be interested in. And so that was a concern again about kind of limiting the access of the property to persons that might not be living in that neighborhood, especially if you could show that that neighborhood was predominantly of a certain race or religion, nationality, et cetera, and other people don't live in that area. So again, it could be a theoretical situation. Whether or not that's happening, I don't know. Because I'm not sure if there has been a study done that has proven that, in fact, coming soon signs are not used in properties in that price point, in a lower price point. So I don't know, again, if that's been shown or not, that they're only being used in higher end properties or only in certain neighborhoods. Yes?
Is there anything that limits your own advertising? So you follow the proper rules in the MLS, you submitted it, withdrawn, you still keep.
So your question is, can you still do your own advertising?
Can you market it?
Oh, so your question is, you're the listing agent, your seller, and you have agreed that you're going to use coming soon, and it's not going to be shown. Can you still advertise the property? Unless there's something in your MLS rules that says you can't advertise withdrawn listings. Is there something in your MLS rules, Jeff?
When it is withdrawn, it does not go out in any of the portals, does not go to any websites, it doesn't go anywhere else.
But could you advertise it in your own website? I know it wouldn't go out in the MLS feed or through IDX, but would you be able to market in another fashion?
You're saying that on your own website, you're showing that the property is active, but yet it's
Yeah.
withdrawn in the MLS.
Yeah.
That's what I know what it's-
Social media, for instance.
Yeah, could you put it in social media on Facebook saying this is coming soon? Yeah, I think you could, because that's a true statement. It is coming soon. So
have to specify a date.
I don't think it's just a coming soon sign, and that's the point you need to make. Is we've all talked about coming soon signage, but it could be other forms of coming soon. And again, if it's not on the market, it's not available to be shown, and that's a true statement, the sellers authorize that form of marketing, I think you're fine. Now, this gentleman just kind of yelled out,
You have to specify a date.
do you have to specify a date? I don't believe your MLS rules. Do they require you put a date in when it's going to go back active? No. Now, one thing I will tell you is that there are a couple MLSs in the state of Ohio who've also grappled with this issue just like you are here in Dayton, and they have created a field in the MLS where instead of being a withdrawn that you would have to search, they could actually look for coming soon properties, and when that property is put in the MLS, they do have to indicate the date on which it is going to be available to be shown. That date, so let's say they put in the date, and I'm going to use Columbus for an example, and I know Columbus, they've had some problems with their new rules, and I think they're revisiting them, but what the rules say right now, and this is similar to what they have in Toledo as well, is you put in the date it's going to be available to be shown. So let's say that date is going to be August 1, okay? So August 1, other realtors can show it, I can show it as a listing agent. I, as a listing agent, under the MLS rules, am not permitted to show the property before August 1. If I would, it would be an MLS rules violation, okay? So let's say it's being renovated. August 1 comes, we're getting close to it, and oh geez, you know, these contractors, this is just theoretical, maybe didn't show up, you know, there's some delays in the work, whatever, and it's not going to be ready by August 1. They could extend it to August 15th. If the listing agent gets a call from a buyer who is coming into town and is moving to Columbus and has to buy a property and wants to see this property, could the agent go in so that they could show the property? Could they go in and change the showing date to July 12th so that they could show it? Under the MLS rules as adopted in Columbus, they cannot. You cannot move that date up, basically to preclude that very situation where the listing agent all of a sudden gets a buyer and decides to change the date so that they can now show it. So that would not be permitted. It's not a foolproof system, and I'll give you one example why. I'm a buyer. I have to buy that property. I got to get in. My family's moving, school's starting, I got to know what school system my kids are getting in. This house isn't available to be shown till August 1st. I love it. I can tell from the outside. I love the neighborhood. I've done all my research. I'm going to make an offer on that property, full price, cash, contingent on me seeing the inside of the property. As a buyer's agent, do I have an obligation to submit that offer? Absolutely. As a listing agent, do I have an obligation to submit that offer? Absolutely. Under the license law, you do. As you as a listing agent, can you stop your seller from accepting that offer? No, you cannot. So now your seller says, this is a full price, cash offer. All I got to do is let these people in, make sure they like the inside, and we're closing in a week. They're coming in. Can you stop them as a listing agent? Probably not. And that has happened in Columbus. They're making curb offers. I'm not saying it's rampant, but it's happening. We've gotten a couple calls on the hotline, and I know the Columbus board's told me it's happening. You know, and frankly, a couple of the calls we got are from the listing agent saying, oh my gosh, I don't feel comfortable with this, but what do I do? Now I'm going to be in violation, I'm afraid, of the MLS rules, but my seller wants this property and wants to let them in, and I can't stop them. And they're absolutely right, they really can't. One of the things that the Columbus board has developed is a form that the seller has to sign when they want to have the property go into the MLS as coming soon. And it talks about the broad exposure of having the property in the MLS. It gives them all the kind of, you know, information about the value of being in the MLS, offering cooperation, et cetera, so that the seller is making an informed consent and the seller signs something agreeing that they understand that the property cannot be shown before that date, et cetera, and the seller signs it. So that there is some informed consent on the part of the seller. They are making the decision, and the MLS has something documented showing that the seller did make that decision not to let the property be shown for this period of time. I know, again, it's not been without controversy within the membership of the Columbus Board of Realtors. You know, they've really had some very, what I would characterize as lively discussions about it. And I wasn't there. This is just what I've heard. And you know, it is an important issue, and so it should be debated. And I think all sides and all aspects should be looked at, and so that's a good thing, right? We don't ever want to just rubber stamp something without really thinking it through, and so I think that's good. And I think if, you know, this is something your board is interested in, you know, it can go through that same vetting process. Again, Toledo also adopted a similar rules with their MLS. I've heard that it's working well in Toledo. I have not heard anybody, you know, complaining up in Toledo about it, but it could be going on and I just don't know about it. But those are the only two MLSs that I know that have adopted that. Again, other MLSs, I think Normals, which is the North Ohio Regional MLS, it's kind of spans a lot of Cavalier land, has some rules as well about properties coming in and out, et cetera, and I think theirs have worked okay.
Just to be specific, if sellers' directions ignore MLS guidelines, for instance, you go to list the property and they say we don't want it on the market for 21 days, you basically have to tell them, I have to put it on as a withdrawal status for 72 hours, active, withdraw, and active again. They say, well, we don't want 21 days on the market to show. Your option at that point is not to take the listing, but put it coming soon and sign out front in the hopes that someone else doesn't try to get that listing, correct?
That's correct. I mean, you
without ignoring the MLS.
I mean, you do not want to violate your MLS rules, and if a seller wants you to take a listing that would violate those rules, I think you need to say to them, no, you know, I'm a participant of the MLS and I'm going to follow the rules. Of course, if you choose to ignore the rules, then there are consequences and penalties, et cetera, for violating the MLS rules. It's the same thing with like going pending, right? A lot of times sellers don't want the property go in the MLS as pending when they have a pending contract, because they think they're not going to get any other offers and they want to be able to get other offers in case this deal falls apart. You have to say to them, the MLS rules require me to put it in as pending. And that's what I'm going to do.
So the biggest problem we have, Peg, is that, you know, the members look at the board as the party that's supposed to be looking after this and making sure that these things all are done properly. However, the board has no idea whether there's a listing agreement. I mean, if you drive by a sign and you call and they say it's listed, if it's not in the MLS within 72 hours, you didn't call and make a complaint.
Yep.
I mean, that's the only way the complaints are going to get made.
Yeah, Jeff is a really, really smart guy. Jeff Ullery is your MLS director, but he's not clairvoyant. Are you, Jeff? He does not know that there's a property out there in, you know, Beaver Creek that has a coming soon sign on it, that it didn't get put in the listing and then in the MLS and then withdrawn. Somebody has to let Jeff know that. He's really talented, but he's just a little weak in the clairvoyant status. Yeah, Georgianne?
Since we have the MLS people here, and I listened to Mark's comment, I did not think it had to be turned
Okay, let me just make this,
Written into the listing itself, it has to be a separate letter.
It can be either way. We just have to have that documentation here on file that says that's what.
It doesn't be 5 minutes later, then, right?
sure.
Okay.
Yeah, I mean, forget coming soon signs. You could get a listing today. You could get it signed. Okay, Saturday, Sunday, don't count, right? So she's going to have till like, what, next Tuesday, Wednesday to get it in the MLS. She could call one of her buyers when she signs that listing. She could call several buyers she knows that are interested in a property in that marketplace and that price point with those features, and she could sell it, and it's going to go in pending right away. Forget coming soon. Coming soon has nothing to do with it, right? Every listing agent in this room could do that, right? And is everybody else going to be mad? Yes, you're all going to be mad because you had a buyer that would have been interested in that property. Life's not fair sometimes. And if you're looking for everything to be fair, you're in the wrong business. Now, let me do this. Before we take any more questions, because you mentioned pocket listings, and I want to talk about pocket listings. Because I think sometimes we lump pocket listings in with coming soon signs. And they're not necessarily the same thing. A pocket listing is also referred to as an office exclusive. Now, sometimes I've seen in different parts of the country, they're calling them off MLS listings. They're giving them different names, but basically they all mean this. It's a listing in which cooperation and compensation are not being offered to other realtors. It might be for the entire term of the listing. It might be for a portion of the listing. So, let's say you are, LeBron James, and you decided that house up there is just a little too small, and now that you won a national championship, you need a bigger house because everybody knows where you live and they're lining the street. So you're going to sell that big, huge house up there outside Akron. You don't want it in the MLS, and you probably don't want every other realtor to show it, right? So you're going to list it with Peg Ritenour Realty, and it's going to be a pocket listing, and only I can show the property. If I'm not offering cooperation and compensation to other realtors, can I put it in the MLS? No. Okay? Can't go in the MLS unless you are offering compensation. But if a seller decides that they do not want their property in the MLS, they do not want other realtors to show it, they don't want cooperation offered, they may have some legitimate reasons to do it. They're a celebrity. They have privacy. They may have security issues. They may have antiques. They may have valuable art. They may just, be concerned that somebody's going to break something or steal something. Whatever reason it is. You may think it's silly, but it may be their reason that they don't want anybody but you to show the property. And again, that's a seller's prerogative. I think we all want to make sure that the seller's making, again, an informed choice about the value of broad exposure through the MLS, through Realtor.com, that you're going to get to a property. One of the things that's not a good reason to have a pocket listing is so that you can have both sides of the commission. Now, when I say that, there's not a realtor in this room that does not love it when you sell your own listing and you get the full commission. And if you're going to sit there and say, oh, I hate when that happens, you're lying. Everybody likes to get both sides of the transaction. But hopefully, you're not convincing your seller to do a pocket listing so that it will benefit you and you get to keep both sides of the listing. It should be what's in the seller's best interest. And the seller, again, gets to determine what's in their best interest. And in making that decision, you want to make sure they're making an informed choice about the pros and cons of a pocket listing. So let's go back to the coming soon. So when you have a coming soon sign, you've got an exclusive right to sell, most likely. You're going to offer cooperation and compensation to other realtors. It's just that the seller does not want it shown during this window of time for whatever reason the seller has determined is in their best interest. Okay? So it's not that they're not offering cooperation and compensation. They're going to do it, however, it may be delayed for a period of time. So again, we have the same provisions that we look. Oh, I keep pushing that wrong button, Nick. Again, you have the MLS rules. You have to get it into the MLS. Even if it's a pocket listing, you have to submit it to the MLS and then do the withdrawn and have the instructions either in a separate document or some notation on the listing contract itself in which the seller, states they do not want it in the MLS. You want to make sure that you're, complying with the Realtor Code of Ethics, which require you to cooperate unless it's not in the best interests of the client. You want to make sure the seller's making an informed decision about what is in their best interests or not. You could have the same fair housing concerns if you're not allowing other people to show it based upon an attempt to limit those persons that can buy the property based on their membership in a protected class. So that definitely could be a concern. A lot of people have raised concerns where these off MLS listings have become very popular, like out in California and other markets. They become so common almost that it's really skewing the comps and things. And there's concern about that and the integrity of the information that's available through the MLS and the data that you're providing on solds, et cetera. So that's a legitimate concern as well. So, you know, again, is every pocket listing a violation of the license law? No. Is it every pocket listing a violation of the Code of Ethics? No. Could it be? Possibly, yes. Depending on the situation, whether or not the seller's making a decision with all the facts and information about the benefits of the MLS and in offering cooperation, and whether or not they're making the decision themselves as to whether or not they want cooperation offered. Yes?
It's the same thing with the pocket listings. Could an agent then advertise with signage on a pocket listing?
Absolutely. Her question is, so I've got a pocket listing. I got LeBron's house listed. He just doesn't want it in the MLS. Absolutely, I can advertise it. I'm going to put an ad out in USA Today. Sign, the whole 9 yards, Facebook, etc. Well, how else am I going to sell it?
Well, that's what I was, yeah. What's the point if
Yeah.
you can? But
Yeah.
it's,
You're just going to have to use a different marketing strategy beyond the MLS.
yeah, it
Yeah.
complicates the issue.
Yes, it does. Yeah.
Peg, I just wanted to briefly mention to everyone, Section 1.3 of the MLS rules covers this. If anybody wants to do some reading on that, it's titled exempted listings. It describes the process, what needs to happen.
Okay. All right. Yes.
When you do a pocket listing and you're not putting it in the MLS, but you're doing all your forms for the state awards and DABR awards, do you have to put it in the MLS to count it towards those awards?
No.
Okay. Well,
There's a separate form. You would contact Kathleen Vigil for those types of properties that sell, and she has a form that we fill out.
Okay.
all right. There's another question. Yes.
Did you say, even as a pocket listing, it needs to be put in the MLS and then withdrawn, just like coming soon?
That is the way our MLS rules state, yes. We need a piece of documentation from the seller stating that they wish it to be off the market, not disseminated.
Yeah, see what that does is and that's beneficial really to you as the listing broker, because you're showing the reason why that I am complying with my MLS rule obligations to submit the listing. However, I'm demonstrating to you that per the seller's instructions, he does not want it in the MLS. And it's going to help you because then when other realtors call and they complain to Jeff, he's going to say,
And so other people will call and complain, and I need something that says.
yeah, it was submitted in a timely fashion per the MLS rules, but per the seller's instructions, he did not want it in the MLS. Yeah. I mean, does that happen that often? Again, you may have a lot of coming soon signs, but do you really have like pocket listings that much? I don't think they're that common. I mean, they did definitely catch on, and you know, as I said, there's legitimate reasons for security and privacy concerns, but I just can't believe that we have that many more properties today than we did 10 years ago where there's all these privacy and security concerns. Okay, anything else about coming soon signs and pocket listings? All right, a parting comment from Georgianne. Excuse me.
You see all the other MLS rules for the other, like larger cities in Ohio and other boards. Do all of them say you have to turn it in and take it back out? Is that a common denominator? Are we unusual in requesting?
I don't think you're unusual in requiring that, because I think most of them want to see that the listing is submitted or why it's not submitted. And some of them may have a form, I don't know. Jeff would probably have a better idea than I do.
It's handled differently by each MLS, but most all of them have this common rule set for many are adopted that says that they
Okay, all right. Look, it only took 45 minutes. So we got 15 minutes to cover probably 45 minutes of material. We're going to talk about for sale by owners first. So you represent a buyer. Your buyer wants to see a for sale by owner. The very first question you should ask yourself is, Okay, if I'm going to show them this for sale by owner, what's my role going to be? Who am I going to represent? Am I going to represent just my buyer and the seller is going to be unrepresented? Am I going to try to take on representing the seller as well, which means I'll be a dual agent? So what role am I going to play in this transaction? That's an important conversation to have with your client, who probably has some expectations, right? And that expectation probably is that you're going to represent them. And then the second question you want to say is, geez, I love real estate, it's my passion, but I don't do this for volunteer work, and I sure would like somebody to pay me, and let's see, who's that going to be? And let's address that up front to make sure that I'm not working for nothing in this deal if my buyer purchases this for sale by owner. So those are some of the two big issues you need to think about before you even go and call that seller to list that property. What I see a lot of realtors do is they'll say, great, I can show it to you, let me call the seller. They do think about the getting paid part. So they pull out what is a regular, good old exclusive right to sell contract, and they call it a one-time listing or a one-party listing in which the seller does say, yeah, I'll pay you X% if your buyer purchases this property, and then they sign that document. If your intent was to be a dual agent and your buyer was fine with you being a dual agent, then you're probably okay. But if your buyer's intent was that you were going to represent just the buyer, by signing that listing, you have just created what with that seller? An agency relationship, which means you represent the seller, you already have agreed with the buyer that you represent them, so now you're going to be a dual agent. And your buyer may not have intended that or expected that or want you to do that. So you covered the getting paid part, you did a good job there, but you really shouldn't have used that form to do it. So before you even show that property, I think you need to say to your buyer, okay, do you want to pay me on this for sale by owner? Maybe you already have an exclusive written buyer agency agreement, which would be awesome. How many people here use one? Okay, quite a few of you, great. So if you use that document, it probably says something to the effect of, I will seek my compensation first from the listing broker or the seller, but if they don't pay me, you will. So you're going to be covered. You can say to the buyer, sure, we'll call this for sale by owner. I will do everything I can to try to get the seller to pay me. But if they don't, you understand you're going to pay me. And hopefully the buyer is like in agreement with that. So then when you go to the seller, you don't need the seller to sign a one-time listing, do you? Because you're going to represent just your buyer. You say to the seller, I represent the buyer. However, if my buyer buys this property, will you pay me X% commission? If the seller says sure, then what do you want to do? You want to get something in writing. You want to have some type of a document. Now I know your board has a form Nick shared with me that's kind of a, what is it called, Nick? A broker fee agreement. I really would not recommend you use that document because that talks about a listing broker and it talks about cooperating broker. It's just not, you would have to make so many changes to it. I think, you know, I'd be a little bit concerned about you using that. I think your brokerage really needs to have a form that's available for your agents to use in this situation that says that the seller agrees to pay a commission of X% to the buyer broker. Put an expiration date in there on how long that's going to be in place so it's not for life. Probably put the fair housing language in there. It's starting to look like in some kind of an agreement that the division's going to want to see the fair housing language in there and put a very clear statement that they understand that you represent only the buyer, you do not represent them, and they can seek representation from their own counsel. But they do agree to pay you as a buyer broker this amount of money. Then, great, schedule the showing. The other thing I see a lot of folks do is they don't have a one-time listing signed, but they really don't address commission maybe up front. They wait and do it in the offer to purchase. So they show the FSBO to the buyer loves it, so now they put in the purchase contract, seller to pay buyer broker fee of X%, and the seller's like, well, yeah, no, not doing that. Now we've made it part of the negotiation, so now your buyer's looking at you and saying, well, wait a minute, now you want me to pay you? And the buyer's saying, I'm not paying you, I don't have enough money in the pot to be paying you, plus buy this dream home and get a down payment and all my costs, etc. So now you got a situation where you got buyer and seller want to get together on terms and nobody's agreed to pay you. So that's not a good day. That's just not a good day, you know. I actually had a commercial realtor that had that situation, a commercial transaction. Just assumed the seller would pay him. They tried to handle it through the negotiations, and he wouldn't, and the tenant wouldn't pay him. And it was a, you know, like $1 million deal. And he had nothing from anybody ever agreeing to pay him. I'm like, how'd that happen? It's because you make assumptions and things fall between the cracks. And you just think everybody will do the right thing, and sometimes they don't do what you think is the right thing. Okay, so, yes?
I wanted to make a real quick comment regarding MLS on for sale by owners. One of the issues that we're starting to see in the marketplace right now is the buyer agents are putting listings into the MLS and closing them when they have a for sale by owners. Do not, and I underscore, do not do that. Number one, you're not the listing agent. You're not in the habit of putting in a listing in the MLS when you're a buyer agent. And number two, it messes with the statistics. If that property was not marketed through the MLS, do not put that listing in and then close it out and say, well, here's this property for homes. That does not work. Do not do that.
All right, listen to Jeff.
Thank you.
All right. Okay, let's talk a little bit about minimum service listings. Back in 2006, Ohio license law was amended to address the issue of minimum service listings. And what we mean by that, sometimes they were called limited service listings, or listings where the seller decides that they do not want the traditional full services that most brokerages provide. And instead, the seller wants to perform some of the services for themselves, some of the steps themselves in the home selling process. They may want to handle their own showings. Sometimes they want to do their own marketing. Sometimes they want to handle their negotiations themselves. And so that was reviewed by a task force. Recommendations were made, and the Division of Real Estate adopted some provisions. Basically, these are legitimate listings. It may not be a business model you like. It may not be a business model that you want to follow for your clients or customers, your clients, but it is certainly one that has a place in the market, and sellers should be allowed to hire somebody to do less than what a typical realtor does in performing, you know, the array of services that are usually involved with a listing. So they are legal. Under Ohio law, however, the Division of Real Estate wanted to make sure that the seller understands what they are getting and what they are not getting when they enter into a minimum service listing. So they developed a form. It's a mandatory form. It was one of your handouts out at the table. It's called a waiver of duties form. And so if you as a listing agent are not going to do the advertising, you're not going to show the property, you're not going to handle negotiations or any of those items on there, you have to have that form filled out by the seller. And you have to check off what things you are not going to perform so that the seller can waive your obligation to perform certain services. What the seller cannot waive are your fiduciary duties of loyalty, you know, confidentiality, obedience, you know, acting in the seller's best interest, all those types of things. So the division won't let you waive kind of those umbrella general fiduciary duties, but as far as certain steps and specific services, those can be waived. So that form needs to be signed by the seller. Usually, again, these minimum service listings are exclusive right to sell agreements and therefore are accepted into the MLS. In order to put it in the MLS, they do have to offer some compensation to other brokers, no matter what it is. The NAR, OAR, the Dayton Board of Realtors, and your MLS cannot dictate what people offer in there. But it has to be something higher than zero, okay? And the reason for that is so that you know what you are working for. And if you see in there an amount that you do not feel is going to be sufficient compensation for you, then you have the right to say to your buyer, there's a listing in here, it meets your needs, however, they're really not offering me compensation that's going to be worth my time and trouble in getting this deal closed. So if you want to purchase this property, you can either contact the listing agent directly or you could agree to pay me. So let's say, for purposes that this property's in the MLS, and let's talk now about your role as a buyer's agent. We kind of just started down that path, and that if you don't want to show that listing, that's your prerogative, but I think certainly you have a fiduciary duty if that's a property that meets your buyer's needs to make sure your buyer's aware of that property. But how far can you go in your contacts with the owner of the property? So it's a minimum service listing, you see it in the MLS, and it says contact seller to arrange showings. Can you call the seller to arrange the showings? Yes. You've been given the authority to do that by the listing agent. And that's important to get that type of consent from the listing agent, because under the Realtor Code of Ethics, there's a provision that says that all dealings must go through the listing broker, unless the listing broker consents otherwise. So you want to have something that you see in which the listing broker has authorized you to deal with their client directly. So if it says all showings, can be scheduled directly with the seller, and here's the seller's contact information, that notation in the remarks section of the MLS is sufficient for you to make that contact with the seller. Okay, so now let's say your buyer wants to make an offer to purchase on this property. Now it gets a little bit more specific, because now we're talking about negotiations. And under Ohio license law, there's a provision that says that if you know the property is exclusively listed with another broker, you cannot negotiate with that seller unless you have the written consent of that listing agent. So what you need to do before you submit that offer to purchase and negotiate with that seller is make sure you have that written consent. Could that written consent be in the form of a remark in the MLS? Absolutely. But you need to be sure you're looking at what that says in the remarks section. Because if it just says call seller for showings, is that the same thing as negotiate? No, it's not. In the license law, this is how negotiate is defined. Delivering or communicating an offer or a counteroffer, discussing or reviewing an offer or counteroffer, facilitating communications, and preparing any responses directed. If the MLS remarks section says you may negotiate directly with the seller, then you can do all of these things because it's in writing and it's from the listing agent. So you're fine to do that. But be really careful on these minimum service listings to see exactly what authority you have been given with respect to your contacts with the seller. The magic word you want to see is negotiate. Okay? And if it just says showings, then you need to call the listing agent and say, listen, I need you to send me an email or a text or something saying I can negotiate directly with your seller. Okay, yes?
If the term negotiation is in there, does that give you the opportunity to go and negotiate a fair commission for yourself prior to presenting an offer?
Okay, we're getting there. So hold on. All right. Before we get to the commission, let's talk about some of the other issues. This is something I hear. My buyer wants to buy this property. They are offering me compensation I'm okay with. But now I'm worried because now the seller wants me to help them. The seller's asking me all these questions. I'm basically, if I hear this once, I've heard it 25. I'm doing their job for them. But I'm only getting the buyer compensation. But I'm doing the listing agent's job for them. And sometimes they're concerned that somehow they're going to imply an agency relationship with that seller. Well, that is a concern. Luckily, there are a couple provisions in Ohio's license law that address that. First of all, there's a section that says that negotiating with the client directly pursuant to the instructions of the listing agent does not create or imply an agency relationship between you and the seller. There's also a section that states that you can perform certain functions with someone who is not your client, with a seller who's not your client, without implying an agency relationship. That you can provide them with information about lenders, inspectors, title companies, etc. And you can provide them with market information that you've obtained from the MLS or other public records. So if the seller is asking you for that type of information, you can provide it without somehow creating an agency relationship with the seller that you didn't intend, which would then make you a dual agent because you represent the buyer. So there are some protections in there. The thing that's important is that you not go beyond kind of those limited functions and just giving them information about other steps in the process or other professionals that they could contact or market information that's in the MLS. You certainly don't want to refer to yourself as the seller's agent. You don't want to refer to them as your client. You don't want to take any action that would imply that you are looking out for their best interests or keeping their confidences. So you need to make sure from the very beginning that seller understands, I am here solely as a buyer's agent. I'm negotiating only on behalf of the buyer. I can provide you with some general information, but I am not your agent. I'm not looking out for you. Don't tell me anything you don't want the buyer to know, because if you tell me something, I'm legally obligated to tell the buyer because that's my client. So don't be telling me your negotiating strategy. Yes?
Like, what do you do when you have an agent, a limited service agent on the other end who basically gives you permission to do all this, set the showings, negotiate, etc., and then once you've got the offer going that's been accepted, basically will not fill in the last page of our contract with any of your information. You send them page 7, they say, I'm not filling that in, send me copies of all the documents for that.
Okay. Her question is, so that you've got this situation, you're authorized to negotiate, but the listing agent won't fill in their name, their license number, and those types of things. All you can do is put a note in the file that you've asked for it, and then, you know, somebody else is going to be asking them for it.
And are you obligated to send that agent any copies of anything? Could you not just say, you should ask your seller with your limited service?
I'm sorry, what?
Are you obligated to give that agent copies of everything once it's executed, since they are not involved in anything else that you're asking for? Can you say, you should ask your seller for copies at the end?
Okay, her question is, do you have to provide copies to the listing agent of all the paperwork? The license law requires it for you to keep your own copies. It requires you to give a copy of anything somebody signs to that person at the time they sign it. There's nothing specifically in the license law that requires you to provide documents to the other side of the transaction that I'm aware of. You know, the division's got this broad umbrella of misconduct. Whether or not they would consider that an obligation or not, I don't know. I mean, why not? Just give it to them. But if you don't want to, you may be okay under the license law, but I would make sure you give it to the seller. And then the seller can give it to them if they want. Okay, so we already talked about, can you refuse to show? Negotiating with the seller for buyer compensation. So let's say you don't like the compensation that's in the MLS. Okay? There are provisions in the realtor, well, first of all, the license law doesn't address this at all. Okay? There's nothing, you know, in the license law that talks about this. In the Realtor Code of Ethics, there's a provision that says that, of course, the listing broker determines what compensation they will offer. Can you call a listing broker and say, you know, it's a little low for me, it's not really working for me, would you pay me more? Absolutely, you can call the listing agent and ask them if they'll pay you more. But if they tell you no, that's the amount that's in there, then that's the amount that's in there, that's coming from them. You cannot make an offer contingent on the listing broker paying you a higher fee than the listing broker has agreed to pay you. Okay? That's a violation of the Realtor Code of Ethics. Can a buyer put a provision in a contract saying to the seller, okay, this is my buyer's agent, I would like you to pay X% compensation, Mr. Seller, to my buyer's agent? Yes, that can be done. But it's really, oh, this mic, I'm having problems. It really has to be really something coming from the buyer to the seller, asking the seller to pay the buyer agent more compensation. Now, in some cases, you will have a seller who will say to you, right, you're showing the property, you're submitting the offer, they do need help, they don't know what the heck they're doing, right? They do want somebody to help them, and you say to them, you know, I represent the buyer, and they say, well, could I hire you to do these things for me? Again, that's something you would want to discuss with your buyer first, right? Make sure your buyer is going to be comfortable with you now being a dual agent. But if they do, then you could do that, and I think you could be compensated for performing services that are not covered under the other listing contract. So if under their listing they're not going to do these things, then you can offer to provide a service that's not covered in that listing contract, and I think you're free to ask for compensation for performing those other services for them. I mean, every once in a while I'll get a call from a realtor who will say, I got contacted by a seller, they had their property listed with another broker, they went with the minimum service broker because they thought they could handle things themselves, and now they realize they can't handle things themselves, and the minimum service broker says, I'm sorry, this is my only model, I'm not going to do these other services for you. Can they hire me to do those other services? And again, as long as it's not covered under the existing listing, you could. It's pretty unusual, and I'm not sure why you'd want to get involved in that, but you could. You could. Okay. The last thing, we're at our hour of 11 o'clock, is I want to mention is the antitrust implications. Whenever you have a business model that may be different from your business model or from maybe most of the people in your marketplace, you always have to be very careful about some antitrust risks involved with that. We certainly don't want to have a situation where any of our members unknowingly get themselves into a problem with the Justice Department. So we would not want two people in this room, either in this meeting or out in the hall or in the parking lot or after the meeting, to call each other and say, yeah, Pat, I hate those minimum service brokers that Peg talked about. You know, let's agree that we won't show their listings, because I'm a pretty big player in the marketplace and you're a pretty big player in the marketplace. And, if we just don't show their listings, maybe they'll just go away. Or maybe they'll start paying more money. Let's agree we're not going to offer them compensation so that they'll up the compensation they're offering us. Or somebody posts on Facebook, did you see what so-and-so's offering on this listing? I'm not working for that, and neither should you. Let's all send them a message, blah, blah, blah. That has happened in Ohio. And that could get you in trouble, perhaps, with the Justice Department. What's called a boycott is when you have 2 or more people who come together and engage in a practice that's designed to force another competitor in the marketplace out of business, or to try to get them to comply with or conform to what are the other norms in the business. So you always have to be very, very careful about that. I just wanted to mention that to you. It may not be a business model that you want to offer your clients, but there are clients out there that do want to avail themselves of that type of a listing, and they do a good job, and the sellers are able to handle their own showings and have either handled their own negotiations because they've watched a lot of HGTV and they know how to do that. Or stayed up late night watching those infomercials, or they're really smart and they get a lawyer to help them. Right, Ann? Yeah. All right, we're not going to have time to talk about handling offers and contracts today. The one thing I guess I would tell you with multiple offer situations, as I mentioned, is you're always going to have somebody unhappy. Hopefully it's the other realtor's client, not yours. But I think the biggest thing you can do with your clients, your buyer clients, is to really spend time with them up front, talking about the current market conditions, talking about how offers are handled, that it's an offer, not a contract. It's not a contract until it's accepted. Use the correct terminology. It's kind of one of my little pet peeves. Sometimes I spend 10 minutes on the phone with the realtor thinking they had a contract, only to find out we were still negotiating offers and counter offers because they're calling their offer a contract. So it's an offer until it's accepted. Let them know they have no God-given divine right because they were the first person to make their offer. There's no hierarchy among offers. Sellers are free to consider whatever offer they want and whatever order they want. They don't have to counter their offer. They can refuse a full price offer and counter for more, all those types of things. I think it's really good to go over all those various scenarios and how things will work in a multiple offer situation before you're in one. Because once they're making an offer, right, everybody's emotions are high. Everything's elevated. They're all excited. They want their house. They know it's a competitive market out there. They're on edge. They're not hearing half of what you're saying, right? Even on a good day. I probably don't hear half of what people say. But we all want to make sure that we're doing it when it's in a calm environment, when hopefully they're digesting what you're telling them, and then when you get in that situation you can say, okay, remember how we talked about this before, that you may not know there's a multiple offer. The seller doesn't have to let you know that there's another offer on the table. They don't have to give you the right to raise your offer. You need to make your best offer. All those types of things that you want to go over with them. So I will stick around and answer any questions afterwards. Again, I want to thank your new EO, Andrew, for having me here today, and Nick for making the arrangements, and Jeff being my backup, and also your president, Michael.